State your name, please, sir, for the record.
Swanger.
Mr. Swanger, I'm Judge Murphy. Do you agree to see me by video?
Yes, sir.
All right. Mr. Swanger, your address is 3714 Refuge Road in Central. Is that correct?
Yes, sir.
You're in front of me for a bond hearing on a charge of manslaughter, involuntary manslaughter. That's the charge as it's listed on your warrant, sir. This is a felony. If you are convicted, it carries a penalty of not more than 5 years in prison. You are scheduled for General Sessions Court on March 27 at 9 o'clock in the morning. This is not your trial time. This is your sign-in date with the solicitor's office. If you fail to make this appearance or any other required appearance, a bench warrant can be issued for your arrest and you will be returned to jail. Now, when the time comes for you to be tried on this charge, sir, you have the right to plead guilty, and you have the right to plead not guilty and request a jury trial or a trial by the judge. You also have the right to be represented by a lawyer. And if you cannot afford to hire a private lawyer, you may get a public defender if you qualify financially. Now, I already know that you have no record, so please listen closely. I'm going to explain how you do all of this. If you want to get a public defender, you have to go to the Anderson County Courthouse and pay the $40 fee and apply for the public defender at the clerk of court's office. After you filled it out, the clerk of court will determine whether or not you qualify under the federal poverty guidelines. If you do, then the public defender will be appointed to represent you. A letter will be sent by their office to your central address, giving you the name of the lawyer assigned to your case and requiring you to make an appointment to see that lawyer so that the process of representation can be started. Okay? Do you understand?
Yes, sir.
Okay. While you are in jail, you automatically qualify for a public defender. You get your name on the list to be seen by them. They come through usually on a daily basis, or you can make arrangements to call them from a special phone they have down there. All right, sir? Please understand that if you are represented by the public defender while you are incarcerated, as soon as you are not incarcerated anymore, they no longer represent you. You would then have to go to the courthouse and apply, and if you qualify and they're appointed, they will represent you again. Do you understand?
Yes, sir.
Okay. All right, so you also have another right, this being a general sessions offense. It's called the right to a preliminary hearing. A preliminary hearing is a hearing in front of a magistrate such as myself, where the state is required to present evidence for the court to determine if there is probable cause that you committed the crime of involuntary manslaughter. Please understand, probable cause is a much lesser standard than the guilt beyond a reasonable doubt that is required at trial. It is merely a preliminary hearing to determine probable cause as to whether or not the case will go further. If probable cause is found, the matter is sent to the grand jury for indictment and subsequent prosecution. If probable cause is not found, the matter will be dismissed. But under South Carolina law, the solicitor can still take the case to the grand jury for indictment and subsequent prosecution. You do not present any evidence. You don't testify. You, or if you have a lawyer, your lawyer gets to ask questions at this hearing to try to show the solicitor that there is no probable cause for this charge. Okay? You're trying to give the solicitor reason not to go forward. That's the purpose of the hearing. Do you understand?
Yes, sir.
Okay. If you want a preliminary hearing, and frankly, lawyers request them all the time, but if you want a preliminary hearing, you are required to request it in writing within 10 days of today's date, the date I set your bond. Okay? There is a form with your bond paperwork that you can use to make this request. You sign that form and either mail it back to us at the address on the form or sign it and give it to a detention officer, and they will get the request back to us. Do you understand?
Yes, sir. Yes, sir.
Okay. Do you have any questions about any of the rights that I've given you? I cannot give you legal advice, but I can explain any of these rights that you may have questions about.
Yes, I understand.
All right. I will give you the opportunity to speak in a minute if you wish to do so, but first I am going to hear from Ms. Meeks, the mother of the victim. Ms. Meeks, I'll give her the opportunity. Ms. Meeks, is there anything you would like to say?
Yes.
Okay.
I love her.
Well, just 1 second. Will it be? Okay. If you would come up here, he will get a chance to hear what you have to say. No?
I'm not worried about being on camera now.
All right. Yes, ma'am.
I know Hunter loves my daughter as much as we do, and I know that this was accident. I'm sure of it. And I know that he's got to live with this the rest of his life. And I love Hunter like my own son. And I don't think that he needs to sit in jail right now because he needs to take care of himself. Nothing that anybody does now is going to bring my daughter back. But I need him for support because my daughter had a child that he helped support.
All right. Let me ask you this.
Yes, sir.
I will be setting a bond.
Okay.
Okay. My determination is whether it's to be a surety bond or let him sign his own, what's called a personal recognizance bond. And the decision, as I told you before, I was trying to explain the process, is based upon whether or not I believe that he will appear or not appear in court, and whether or not I believe he will be a danger to the community at large or not. Now, do you consider him to be a danger to you or your family or the community?
No, not at all.
All right. Do you have any reason to believe that he would not appear in court?
No reason to believe that, no.
Okay. He has no criminal record.
Right.
And even with knowing that, I still would like your opinion on, which is why I'm asking you. I'm sorry to belabor this, but is there anything else that you would like to tell me about this?
I can't think of anything right now. I just know that I don't want him sitting in jail.
Okay.
Thank you.
All right. Ms. Meeks, thank you very much. Your mother is also here. I will give her an opportunity to address me on this issue of your bond if she wishes. Do you wish to speak, Ms. Swanger?
Yes.
Okay. All right. What would you like to tell me?
He's not a danger in no way, and he's not going to run. I will make sure he's here. He takes responsibility for his actions. He's never ran away from him. He knows that accident.
Is there anything else you would like to tell me?
He's not a danger. He's not going to run. Our whole family works at the same company. He's got a full-time job.
All right.
Thank you.
Thank you. Mr. Swanger, I'm going to ask you some questions, and I will give you the chance to speak if you wish to do so. Please understand you are being recorded, and anything that you say could potentially be used against you in court, okay? Now, I'm certainly not going to ask you questions about the facts, but I want to know, your mother said that your whole family works for the same company. I don't have that information here. What is the company?
Consolidated Southern Industries.
Consolidated what?
Southern Industries.
Southern Industries, okay. How long have you been working there?
almost 2 years.
Okay. You're 21, so before that, did you work?
Yes, sir.
Okay, and where did you work then?
I worked at a yardscaping company in Easley.
Okay. All right, sir. As I said, I already know what your record is like. It's non-existent. So if you wish to say anything to me about the issue of your bond, I will be glad to hear it. Please do not forget you are being recorded, and anything you say could be used against you. I'm not interested in hearing from you about the facts of the case. I'm interested in hearing from you if you wish to say anything about the issue of your appearance in court and whether or not you're a danger to other people. Do you wish to speak on this?
I'm not a danger to nobody, sir. I'll make every court appearance. I'll do what I have to do. I mean, I take responsibility for my actions. I did with it.
All right, sir. All right, thank you very much. You have absolutely no record, no arrests even, that have not been expunged from your record. You are, from what I can tell, totally clean. You have a job that you've been working for 2 years. I don't have anything to indicate there's any particular problem with you appearing in court or being a danger elsewhere. Based upon that, I have the information from the victim's mother. Apparently, y'all's families are close. And she, of course, your mother said she'll see to it that you make court. From what I understand from the victim's mother, she is not interested at all in you remaining in jail. And she's told me she does not believe that you are a danger to the community or that she believes you're not going to appear in court. That weighs very heavily as to what my decision will be, in addition to all of the other factors. Based upon this, sir, I'm going to let you sign your own bond in the amount of $5,000. You will be getting out tonight. I want you to also understand, sir, this is not a get-out-of-jail-free card. If you fail to do what you are required to do, then you will be required to pay this money. Do you understand?
Yes, sir.
Okay. This can be explained, all explained to you in far more detail if you obtain an attorney. And an attorney can explain far more than I can for this, so you probably should consult an attorney. If you obtain an attorney, sir, they will notify your attorney of various and sundry court appearances, but they also notify you. So you keep in touch with your lawyer, but if you get a card telling you to appear in court, whether you've heard from your lawyer or not, you appear in court. Otherwise, you're going to find yourself with a bench warrant, and you may sit in jail on a bench warrant for a month or two before a circuit judge hears it. You understand?
Yes, sir.
Okay. Your bond is also conditioned upon, obviously, continuing to obey the laws of the state of South Carolina. I will not make any other restrictions because clearly the family relationship here is one where there's going to be a continuation of contact, especially since there is a child involved. Do you have any questions of me, sir?
No, sir. I just like to say thank you.
Pardon me? Good.
I'd just like to say thank you.
Oh, certainly. You're welcome, sir. There will be a number of places for you to sign. You're signing on a pad, an electronic pad that will transfer your signature to paperwork that you will receive concerning this bond. That paperwork is going to have in writing the information that I have provided to you. Okay?
Yes, sir.
All right, sir. There being no further questions, then this hearing is over and you can go ahead and proceed with signing. Thank you, sir.